guys, welcome to Live Law. This is Sanya, and as the year comes to a close, I am here to take you today over the most important judgments of 2020. Today I will be going over 15 of these judgments. We will cover 60 of these in total, and I've divided this in 4 parts. So stay tuned. Kashmir lockdown and internet shutdown. Anuradha Bhasin versus Union of India. On January 10, Top Court delivered the judgment on a batch of petitions which challenged the legality of the curfew orders and internet shutdown which was imposed in Jammu and Kashmir in the wake of the abrogation of the special status of the state in August 2019. A significant takeaway from this judgment is its declaration that freedom of speech and expression and also freedom of trade and commerce through the medium of internet are constitutionally protected rights under Articles 19(1)A and Article 19(1)G respectively. The court observed that indefinite suspension of internet is not permissible and that repeated orders under Section 144 CRPC will amount to abuse of power. The court also added that the government should publish all orders of restrictions and should follow the principles of proportionality to adopt less restrictive measures. Anticipatory bail cannot be limited to a fixed period except in special and peculiar circumstances. Sushila, Aggarwal and others versus State of NCT Delhi and another. On January 29, a constitution bench of the Supreme Court had held that anticipatory bail should not invariably be limited to a fixed period. But if there are any special or peculiar features necessitating the court to limit the tenure of the anticipatory bail, it is open for it to do so. Justices M.R. Shah and Justice S. Ravindra Bhatt penned separate judgments agreeing with each other, whereas Justice Arun Mishra, Indra Banerjee and Vineet Saran concurred with the conclusion reached by both the judges. The court also held that life or duration of an anticipatory bail order does not end normally at the time and stage when the accused is summoned by the court or when charges are framed, but can continue till the end of the trial except in special and peculiar cases. No absolute right of appointment for minority educational institutions. Supreme Court upheld West Bengal Madrasah Service Commission Act. Supreme Court upheld the constitutionality of the West Bengal Madrasah Service Commission Act 2008, observing that there is no absolute and unqualified right of appointment for minority educational institutions. This was a judgment by a bench of Justices Arun Mishra, U.U. Lalit, delivered in the case S.K. Mohammad Raffique versus Managing Committee Contai, Rehmania, High Madrasah and others. The case concerned the validity of the West Bengal Madrasah Service Commission Act 2008, which constituted a commission to appoint teachers in madrasas. On January 30th, a bench headed by CJI issued notice on the writ petition, which sought reference of the issue to a larger bench. Juvenile Justice Act. Offences prescribing maximum sentence of more than 7 years but not providing minimum sentence are not heinous offences but serious offences. Shilpa Mittal versus State of NCT Delhi and another. The Supreme Court observed that an offence prescribing a maximum sentence of more than 7 years imprisonment but not providing any minimum sentence or providing a minimum sentence of less than 7 years cannot be considered to be heinous offence within the meaning of Section 2(33) clause of the Juvenile Justice Care and Protection of Children Act 2015. Invoking Article 142 of the Constitution, the bench of Justices Deepak Gupta and Anirudh Bose held that the category of offences where the maximum sentence is more than 7 years imprisonment but no minimum sentence or minimum sentence of less than 7 years is provided shall be treated as serious offences within the meaning of the Act. Speaker should decide on disqualification within 3 months. Impartial tribunal needed under 10th schedule. Kisham Meghachandra Singh versus the Honourable Speaker, Manipur Legislative Assembly and others. The Supreme Court held that Speaker of the Legislative Assembly should decide on a petition seeking disqualification of a member under 10th schedule of the Constitution within a period of 3 months in the absence of exceptional reasons. Highlighting the importance of taking a decision within a reasonable time, the top court said that the Speaker, in acting as a tribunal under the 10th schedule of the Constitution, is bound to decide the disqualification petitions within a reasonable period, which is a period of 3 months from the date on which the petition is filed, and is the outer limit within which disqualification petitions filed before the Speaker must be decided, provided the constitutional objective of disqualifying persons who have infracted the 10th schedule is to be adhered to. Now, this was held by a bench comprising Justices R.F. Nariman, Anirudh Bose and V. Ramasubramanian in a case relating to alleged defection in the Manipur Assembly. Validity of SC/ST Amendment Act 2018 upheld. Prithvi Raj Chauhan versus Union of India. On February 10th, the Supreme Court upheld the constitutional validity of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Amendment Act of 2018, which was enacted to nullify the effects of the March 2018 judgment of the Supreme Court, which had diluted the provisions of the Act. A child in conflict with law cannot be kept in jail or police lockup under any circumstance, Supreme Court said. Division bench comprising Justices Deepak Gupta and Anirudh Bose observed in the suo motu case in rape, exploitation of children in orphanages in the state of Tamil Nadu that the juvenile justice boards are not meant to be silent spectators and pass orders only when a matter comes before them. It added that they can take note of the factual situation if it comes to the knowledge of the juvenile justice boards that a child has been detained in prison or police lockup, stating that it is the duty of the Juvenile Justice Board to ensure that the child is immediately granted bail or sent to an observation home or a place of safety. Supreme Court directed political parties to publish criminal antecedents of candidates in Lok Sabha and Assembly polls. Ram Babu Singh Thakur versus Sunil Arora and others. Taking note of alarming rise of criminalization of politics, the Supreme Court directed all political parties to publish the details of criminal antecedents of their candidates in the Lok Sabha and Assembly polls within 48 hours of selection of the candidate or within 2 weeks of nomination, whichever is earlier. The information should be published in local newspapers and uploaded on official websites and social media handles of the parties. Information should contain the nature of crime and stage of trial or investigation, top court had said. A bench of Justices R.F. Nariman and Ravindra Bhatt passed the order. Permanent Commission for Women in Navy and Army, the Secretary, Ministry of Defence versus Babita Punia and others. In a significant judgment on gender equality, the Supreme Court on February 17 directed that permanent commission should be granted to women in the army regardless of their service in all the 10 streams where the union government has already taken a decision to grant short service commission to women. The court also held that absolute exclusion of women from command assignments is against Article 14 of the Constitution and unjustified. Therefore, the policy that women will be given only staff appointments was held to be unenforceable by the court. This was held by a bench comprising Justices D.Y. Chandrachud and Ajay Rastogi. Land acquisition. No lapse of proceedings under Old Act if compensation is deposited in Treasury. The Supreme Court 5-judge bench upheld the Indore Development Authority decision in a highly debatable judgment. The Constitutional Bench of the Supreme Court held that proceedings under the Land Acquisition Act 1894 will not lapse if the compensation has been tendered by deposit in Treasury. The court had held that landowners cannot insist that the amount should be deposited in court so as to sustain the land acquisition proceedings under the old Act on the commencement of the new land acquisition law with effect from January 1st, 2014. The bench also affirmed the view in the 2018 Indore development case, overruling a 2014 judgment in Pune Municipal Corporation case. A bench comprising Justices Arun Mishra, Indira Banerjee, Vineet Saran, M.R. Shah and Ravindra Bhatt had heard the matter. Nirbhaya case. Supreme Court dismissed the final appeal of convicts to stay execution after past midnight hearing hours before the scheduled execution on March 20th. The convicts in the Nirbhaya case knocked the doors of the Supreme Court past midnight, hoping for a last-minute judicial intervention to extend their lives. But the last-ditch effort of the convicts met with no success, as the bench comprising Justices R. Bhanumati, Ashok Bhushan and A.S. Bopanna dismissed the plea after a special sitting which commenced at around 2:45 am. At around 3:30 am, the bench dictated the order dismissing the writ petition filed on behalf of convict Pawan Kumar Gupta, challenging the rejection of his mercy petition by the President. The court held that the scope of judicial review over the President's exercise of clemency power was extremely narrow. 2 hours later, the convicts were hanged to death at 5:30 am at Tihar jail. The Supreme Court extended limitation for filing in all courts, tribunals within effect from March 15 until further orders on account of COVID-19, with the objective of reducing the physical filings in courts and tribunals across the country during the COVID-19 pandemic. The Supreme Court passed a general order extending the limitation, whether condonable or not, with effect from March 15 until further orders. The court had said that it was doing so in order to obviate such difficulties and to ensure that lawyers and litigants do not have to come physically to file such proceedings in respective courts and tribunals across the country, including this court. Later, on September 19, clarifying its 23rd order, March 23rd order, the bench of CJI S.A. Bobde and Justice A.S. Bopanna and V. Ramasubramaniam observed that the said order extended only to the period of limitation and not the period up to which delay can be condoned in exercise of discretion conferred by the statute. Supreme Court directed states and union territories to consider granting parole to prisoners in lesser offences to decongest prisons in order to avoid overcrowding in the prisons. In wake of the COVID-19 pandemic, the Supreme Court directed all states and union territories to set up high-level committees to determine class of prisoners who could be released on parole for 4 to 6 weeks. The bench headed by Chief Justice of India S.A. Bobde observed that the prisoners convicted of or charged with offences having jail term of up to 7 years can be given parole to decongest jails. Similar directions were issued by another bench to reduce the congestion in childcare institutions and juvenile homes. Ex post facto environmental clearance unsustainable in law. Alembic Pharmaceuticals Limited versus Rohit Prajapati and others. A division bench comprising Justices D.Y. Chandrachud and Ajay Rastogi reiterated that the concept of ex post facto environmental clearance is against the fundamental principles of environmental jurisprudence. Environmental law cannot countenance the notion of an ex post facto clearance. This would be contrary to both the precautionary principle as well as the need for sustainable development. The court reiterated in light of the observations made in the case of Common Cause versus Union of India. Supreme Court quashed the RBI ban on banking services to cryptocurrency dealers. Internet and Mobile Association of India versus Reserve Bank of India. In a significant judgment, the Supreme Court lifted the curbs imposed by the Reserve Bank of India on regulated entities such as banks and NBFCs from dealing with virtual currencies and from providing services to crypto businesses. The court held that the RBI's circular, which prevented regulated entities from providing banking services to those engaged in the trading or facilitating the trading in VCs, was liable to be set aside on the ground of proportionality. Stay tuned for the second part of this series. We'll be going over more judgments in another video. Bye. Subscribe to our channel and press the bell icon to never miss a video from Live Law.